Welcome to the Crawford Family Forum. I'm Frank Stoltz. We're here tonight with the author of Forcing the Spring, which is a book about Proposition 8 and the fight for gay marriage. Welcome everybody in the audience here in the Crawford Family Forum and also who are tuning in live stream. I'm Frank Stoltz. I'm a reporter here at KPCC. And let's first start by introducing Joe Becker, who is, as has already been said, an investigative reporter with the New York Times, winner of a Pulitzer Prize at the Washington Post with Barton Gellman for a series on Vice President Dick Cheney. You're switching gears a little bit from Dick Cheney to gay marriage. And of course, she's written Forcing the Spring, both critically acclaimed and catching some heat within some sectors of the gay community. Also here in the middle is Terry Stewart, Deputy Chief City Attorney for the City of San Francisco. She won the ruling at the California Supreme Court that legalized same-sex marriages. She was a lawyer in the Prop 8 case representing the city of San Francisco. She was perhaps overshadowed by some of the more famous lawyers in the case, but nonetheless a key player in this battle. And Tori Osborne, at the far end there, a longtime gay rights activist in Los Angeles, former executive director of the National Gay and Lesbian Task Force, and former executive director of the LA Gay and Lesbian Center, and as I think was noted, a former deputy mayor to former Mayor Antonio Villaraigosa. Thank you all for joining us. This is going to be a great discussion of a book that takes us really behind the scenes of a major civil rights case in a way that no other book has done with any other legal case that's gone to the Supreme Court that's been such an important case. And Joe, let me start out by asking you, actually, before we start out with this question, I'd forgotten, we put together just a short video laying the groundwork, taking us back to 2008 and in those days after the passage of Proposition 8.
Want no to Prop 8 because, as you can see, 52% of the vote is for yes, and that's with 96% of the precincts reporting. So this proposition has put California in the spotlight nationwide, and it appears that this is going to happen, which this morning throws into question those 16,000 or so same-sex marriages that were estimated to have happened since they started performing those.
Let's take a look here at how the state broke down on the ban for same-sex marriage in the Bay Area. All counties against the ban except for Solano County, which voted for it. Los Angeles County, a close race, but they passed Proposition 8 by a slim margin here.
Supporters of gay marriage targeted LA's Mormon Temple, protesting the $15 million the church poured into passing Proposition 8. The measure to define marriage was the most expensive proposition fight in the country. Both sides raised $70 million.
The law that the Mormon church has broken is God's law.
Joe Becker, where were you that night?
I was probably in a newsroom covering the national elections.
And what first got you interested in Proposition 8 and its passage?
Sure. Well, I picked up the newspaper, the front page of our newspaper, the New York Times, one day, and I see this story out of our California bureau, and it says that Ted Olson and David Boyce, the lawyers who were opposite each other in Bush v. Gore, had teamed up to bring this lawsuit. And I just thought, well, whatever the story of how Ted Olson, this guy that liberals just love to hate because he won Bush v. Gore, came to embrace this cause. Like, that's got to be a really good story. And I had known both Ted and David because I covered the recount and was in Tallahassee for the entire time. And so I called him and I said, I'd really love to do this story. And my boss is actually initially, this is not my normal fare exactly. I do these kind of very long, kind of deep dive investigations on national security and all these things. But I was fascinated by this, and they said, well, can't somebody else at the newspaper do it? I said, no, because he hates the New York Times. I am the only reporter that can do it. So anyhow, I called it up and I did this story, and I just found I could not let it go. This was such an important battle, and it was something that just captivated me. I've always been so interested in the civil rights fights of the previous century. And this was an incredibly interesting cast of characters, and I met the plaintiffs and talked to them, and I wanted to know how is it all going to turn out? Because, it was very unclear. This was a pretty bold move.
And as I mentioned, you got some amazing access. How did you arrange that?
Well, I talked to them and I said, look, I'd like to do a book about this, and if you'd have to want to have a book done, you'd have to think that I'm the right person to do it, and there's a bunch of reasons that I could think of not. And if all of those things are true, I have to have unfettered access to everything that's going on. I don't want to have to kind of recreate this after the fact. And I had said that, to me, that was like a very crazy bar, because no lawyer lets you wander in and out of their conference rooms. I mean, it was kind of just doesn't happen. And so I just thought that they would say no. And to my great surprise and delight, they said yes.
And when was that? Was that a few months after the passage of it?
It was. This would have been around, when did they file the suit?
Spring of 2009.
Spring of 2009, yeah.
Okay. So take us, if you would, to the Polo Lounge of the Beverly Hills Hotel a couple of weeks after the passage of Proposition 8.
Yeah.
This is the kind of the swank lounge of the Beverly Hills Hotel. You tell a great story of sort of the embryonic stages of this legal battle.
Yeah, so Chad Griffin is a political consultant here in LA, and was at the time. And, he went to the Polo Lounge to commiserate with some friends, and his friends happened to be very famous people. Rob and Michelle Reiner. Rob, of course, the director of movies like When Harry Met Sally. But really, he was like a father figure. And Chad was gay, and he was watching the returns on the night of the election come in, and he had just felt gut punched, that California, of all places, could pass something like this. He was just devastated, as were so many others.
And let me stop you there for just a second. A little bit more about Chad Griffin. I mean, he's this fella from the Deep South who's gay and was closeted for a long, long time.
Yeah, he was. He worked in the Clinton White House. That's where he kind of cut his teeth. And, we talk about in the book how he was afraid to come out for so long because, he wanted to emulate his mentor, Bill Clinton, and could one day run for governor. And he thought to himself, I can't be gay and run for governor, which is a lot of the book really talks about this, that talks about Judge Walker, and who is the judge who heard the case, and himself gay, and his struggle to come out, and this kind of sense of, and it was also a real theme at the trial, and an evidence that was put on, this theme of when you're discriminated against, this kind of diminished sense of possibility.
And so Chad Griffin, from Arkansas, had worked in the Clinton White House, was now in Hollywood as a PR guy, and actually worked for Rob Reiner. We had seen the election of the first black president, but also the passage of Prop 8. And now we're a couple of weeks later at the Polo Lounge of the Beverly Hills Hotel. Chad and his partner in his business are having coffee or lunch with Rob Reiner and his wife.
And this is, this begins, in this moment, what happens is what happens all throughout this case, these kind of moments of serendipity. So they're sitting there, they're discussing it, they're commiserating, and a friend of the Reiners came, and basically, fast forward, they asks what they were talking about, and she said, oh, well, you really ought to talk to my ex-brother-in-law. And, he's a constitutional lawyer, and I think he'd be on your side. And they said, oh, great, who is that? And they said, well, Ted Olson. And it was like, why on earth would we want to talk to Ted Olson? I mean, Ted Olson had championed all these, causes, these conservative causes. And more importantly, the Reiners and actually Rob Reiner and Chad had been at the vice president's home on the very night that Ted Olson was celebrating his big Bush v. Gore victory with Ken Starr and eating caviar. So they thought it was unlikely, but I think they both saw the kind of game-changing potential that if a guy as conservative as this were to embrace this cause, it could change the way people saw this issue and talked about this issue. So they thought, yeah, why not at least sound him out?
And let's talk a little bit more about Ted Olson. He is this arch conservative, but there's more to the story than that.
Yeah, I mean, Ted Olson actually, unbeknownst to anybody at the time, I mean, but when they did reach out to him, he did agree. And what was interesting to me in doing the reporting is it turns out, Ted Olson had this very kind of this view about equal protection in which he sort of thought the government can't discriminate for good or for bad, right? So he had actually fought affirmative action programs because he thought that they discriminated in the name of a good cause, but that it was unconstitutional. And so he pretty much had this view, same thing about the government saying that one group of people could get married, but another could not. And so he thought the bar was really high. And he had a history. He, in 2000, all the way back in 2000, when states were debating things like civil unions, there was a robust debate among some friends. And he said, well, that's just second class. Like, that's not a solution. That's just a political compromise or something. But, he said, people ought to be able to get married, and you're going to see this in your lifetime.
Would this case have happened without Ted Olson?
Well, I don't know that. I mean, you can't say that. I think one of the arguments that was made was that after Proposition 8 passed and they exhausted all the appeals at the California Supreme Court, one of the arguments that was made was that someone was going to bring a lawsuit. So why not have it be Ted Olson?
Yeah. And I guess what I'm saying, it would not have happened in the way that it did without Ted Olson. And again, sort of punching home this point that you're making, Joe, which is this chance meeting, at the Beverly Hills Hotel sort of launched this whole thing. Later, you describe how Ted Olson came to the Reiners home, laid out his legal strategy, and then searched for a co-counsel who would sort of be more acceptable to the liberal gay rights community.
Yeah, I mean, I think he understood, as everyone did, that his involvement in this case would be greeted with a great deal of suspicion, and it was. Some people thought, has he taken it to tank it? Is he pretending to be for us, but he's really against us? And so he did search for a co-counsel to allay fears. And what was interesting in the reporting of this book is that he actually approached several lawyers who turned him down, including Paul Smith. Paul Smith is a lawyer who won Lawrence v. Texas, which was the landmark case that struck down Texas's sodomy laws and said that that's unconstitutional. And Paul, of course, it's not like the idea of bringing a federal case and taking this cause to the Supreme Court was anything that no one had thought of. I mean, it was. Paul had thought of it because in that case, Justice Scalia said, this is opening the door to gay marriage. In dissent, he said this. And so Paul had thought about bringing a case, and he had talked to several Kennedy clerks to Justice Kennedy, the author of that opinion, and the person that many people believed was the swing vote on this issue. And they warned him, and he shared this with Ted Olson. They said, it's one thing for Justice Kennedy to say you can't criminalize private sexual behavior. It may be another thing altogether, though, for him to go and say that all states must, bless these unions by bestowing marriage. And so, he basically told Ted, he said, well, good luck, but I honestly think this is too risky, and I don't know that the court is going to be with you.
Well, because if you get a ruling that says, it's okay to outlaw gay marriage, then you've got a whole new legal battle on your hands. Maybe you could describe that, Terry. I mean, there were the strategy until that point among gay rights activists was a state-by-state strategy, and to not go to the federal courts.
Essentially, when you're looking to make change and it hasn't taken hold yet, asking the Supreme Court to require a supermajority or all states to do something under the Constitution is a really big ask, and they almost never do it because the court has even though in theory the Equal Protection Clause and all the amendments to the Constitution that set out civil rights are not based on politics, in reality the institutional in a sense, role of the court is threatened if the court does things and people don't follow it. And the court still remembers, even though the same justices aren't there, Brown versus Board, where the National Guard had to be brought out to enforce, and it took years and years to get all states to comply. So the court is understandably reluctant to get involved in some of these things. And for the gay community, myself included, if you lived through Bowers and you saw, Bowers was the case in which the Supreme Court said it's okay to criminalize same-sex sexual intimacy, and the repercussions of that decision were horrible. It wasn't, and I think at first Ted and David didn't really understand that. They were like, well, so if you lose, you'll be no worse off than you are now. But we were trying to say, no, we were worse off from losing Bowers because it gave permission to state legislatures, state courts, the lower federal courts to say, you people are criminals, and therefore we don't have to give you any equal protection treatment. There's something wrong with you. And even though denying marriage wouldn't have been quite the same, it still would have said it's okay to treat gay people differently.
You know, there's a great moment in the book where Terry gets involved in this case, and she can remember. I describe how in fighting the California Supreme Court case that led to 18,000 people being able to get married. She told me she carried the pain of the community in her briefcase every day. She was so aware of what this meant and so scared of letting them down, letting this community down. And so there's a moment where a younger lawyer on the Gibson Dunn team, that's Ted Olson's firms, she said, it was this kind of contemplative moment, and she said, well, we could lose, and he said, well, or what if we lose? He said, no, that's why we take the big, we take the tough cases, and it was a kind of a bravado, and it made her feel like, she said, this isn't some antitrust case, like these are real people's lives at stake, and that's a kind of a thing that goes throughout the book where,
She left out the expletive in my sentence.
Well, and there are so many great, scenes here, and one of them is a meeting among gay rights activists and lawyers and Olson, where, Chad and Ted Olson, I don't know if Boyes was involved at that point, but they're saying, we're going to go for it. We're going to file this federal case, and people are going, no, don't.
Yeah, I mean, essentially, it was actually Ted Boutros, a partner of Olson's, because they figured Olson, still at this point, they didn't think he was the right messenger. They asked some of the lawyers who had been working on this for years and years to a lunch at the Reiners, and it was time to kind of let them in on what they were going to do.
Yeah, because they'd kept it quiet.
They
laid
kept
the groundwork
for
several months.
And so they brought them in, and there was they started to say, well, this is the deal, and if someone's going to bring it, you might as well have someone like Ted Olson on your side. And the lawyers all sort of erupted. It's described in the book it's not that they didn't share the goal. I mean, that's really important to understand. Of course they shared the goal, and of course they shared the same legal kind of understanding, that this was that the belief that this was unconstitutional. But it was Bowers. I mean, remembering Bowers, and they tried to sort of explain this. And John Davidson of Lambda Legal told me, it was felt very disrespectful, to them, that they had been thinking about this for a very long time, and they just didn't think that there was 5 votes. And so much progress has been made in the last 5 years that it's sort of hard to really go back in time and remember where we were. But it was 2 states, just 2, that allowed couples to marry. California voters had just gone to the polls and passed Prop 8, and the majority of the country was opposed. And in that climate, they really feared that this tactic, taking this cause to the Supreme Court, it was too fast, the country wasn't ready, and the court wouldn't be ready.
Well, here are these relative newcomers, Tori. I mean, you've been in the battle for quite a while. Here are these.
I remember Bowers in '86, actually.
In
I remember
1986.
what that was like, because that was 1986. A lot's happened.
Was that
since
out of
then.
Georgia? It was Bowers?
Yeah, it was-
Georgia case.
Right.
And so here, relative newcomers, Chad Griffin
Right.
and Ted Olson and David Boyes. When did you first hear about it, and what was your reaction?
Well, I want to actually set the stage a little bit and I want to just say publicly, I think this book is phenomenal. I think it's thrilling. I think it's It's a page turner. I think it's gripping, and I hope everybody buys it and reads it for themselves and doesn't just listen to the kind of just the dialogue, at least some of the kind of negative dialogue. I think there's been a
We'll get to some of the answer to some of those questions in a second.
But let me just set the context here, because in the first scene, and I bet there's people in this room who can remember exactly where you were the night that Barack Obama was elected president and Prop 8 passed. It was a moment that anybody engaged in any way with either the president's campaign, and let us not forget that that was a political campaign that morphed into a social movement that got 13 million people to vote who had never voted before, that had here in California, had tens of thousands of us going to Nevada, Colorado, and New Mexico and turning out the vote, and some of us going and working on No on 8 and then going off to Nevada and sort of having split loyalties and in terms of engagement. But let us not forget that revolutions really are caused by raised expectations that are dashed. And what happened that night was, with one heartbeat, people felt jubilation at not just that it was the first African-American president, but we elected him. The people had spoken, and an unprecedented coalition had come together. And then, boom, at the same moment, rights were taken away for the first time in American history by ballot measure, taken away. Remember, 18,000 people had gotten married. We'd had those weddings in 2004, my favorite civil disobedience of many that I've been involved with. Unfortunately, ended up in divorce, but that's another story. But it was a magnetic stream of those 4,000 couples who performed that civil disobedience, who went to San Francisco. And so Bowers v. Hardwick was 1986. There'd been a huge and diverse and incredible movement that had grown and evolved during that time. So here we have election night, jubilation followed by utter heartbreak and rage and anger. And I don't know how many people in the room here, but in the 2 weeks between election night and that luncheon that you just talked about in the Polo Lounge at the Beverly Hills Hotel, there were 1 million people on the streets in the United States and in 8 countries, in 300 cities. The largest demonstration was right here in Los Angeles on November 15th, Join the Impact. And there was a proliferation of activism, the likes of which I've actually never seen before, and I've been an activist for a very long time. I've never seen the creativity, and in a very interesting way, it was taking the baton, the LGBT community and allies, because many of my sisters from the Obama campaign were on the streets with us in November. It was, in a way, it carried the baton from the Obama movement in this very interesting way, even though the numbers were such that some of the very same communities. And here's why this is important. It's not just because it's a lens, it's a sort of context that's missing. It's a chapter. It's 500 words you could have had in there, and I hope in your next edition you put in there.
Well, but also I want you to answer that question. Like, what was your personal reaction when you heard that Ted Olson and David Boies were going to file this lawsuit?
I actually was talking to Chad during some of this time.
Okay.
I had friends who had been at some of the dinner parties where they were talking to donors
So
and
you
trying
got
to engage
wind,
them.
sure.
I knew about it as it was evolving. And in this and this is why the context that I mentioned is important. What happened as a result of Prop 8 and the campaign against it being so lame, being so bad, was that credibility in the established LGBT institutions was at an all-time low, let's just say. Right. So that, in a sense, along with this vibrancy and the FAIR and the Roots of Equality and the Equal Roots and all of these organizations that came, the Latino Equality Alliance and all of these organizations that sort of came out of nowhere in this moment, this movement moment, there was also a hunger for fresh thinking and that urgency, that fierce urgency of now that President Obama had talked about. It was the younger generation, and many of them are in the room here tonight, thank you for being here, who came onto the streets and who came out of Prop 8 and were supporters of President Obama and carried that baton of activism and civic uprising we're not going to wait for 25 years, which is what people were telling people the state-by-state strategy was going to take a couple of decades. They were not going to wait. They were angry. They were frustrated. They wanted not just to protest, but they wanted a strategy. So it is into that context that the bespectacled young Arkansas Southern boy, this 30-something guy, comes in. Now remember, he's a campaign consultant. Let's be clear about it.
And we're going to get into
Chad
that in just a
Griffin.
second, because this was as much a political and social movement as it was a legal case.
Right.
But I want to stop for just a quick second here and talk a bit about the selection of the plaintiffs in the case, because you got a court case, you got to have plaintiffs. And
sometimes it usually, most people understand it to be the other way around, actually.
right, there's
Somebody
somebody
comes
who
forward,
wants
they
to
want to
sue,
get
and you got to
married,
find a
you gotta-
lawyer.
right.
The lawyers are looking for plaintiffs.
Right, in this case,
and
yeah.
this was, and you described very interestingly, they had to be very careful, or they felt like they had to be very careful about who they picked.
Yeah. So Ted Olson had a very specific kind of list. He wanted, literally he said this, he wanted a bookstore owner, he wanted a police officer, and I think the third one was a teacher. And
You want a nice, clean gaze, presentable gaze.
well, he wanted people who were regular people.
Yeah.
He did not want
As if, right.
celebrities. He did not want activists. He wanted people that were just regular people. Interestingly, because just to fast forward a second, it turns out that one key to Justice Kennedy, the swing voter's heart, at least from the oral argument, seemed to be, well, wait a minute, you're discriminating against. In the oral arguments, Kennedy talked about what about the children of these couples? That was a really important moment in the oral arguments. He was like, what about the children of all these couples? But Ted Olson actually didn't want kids. He wanted plaintiffs that did not have kids. It didn't turn out that way. He had all this list of people, but they did kind of a casting call, literally. They had an elaborate ruse where they said that they were looking for people who were willing to take part in a public relations campaign. They hired researchers to
Opposition researchers.
to dig into their past and to make sure that there was nothing that would sort of embarrass them or come out at trial.
Weird arrests or
Yeah.
infidelity.
Yeah,
It's a political campaign.
even-
Sounds like a political campaign.
Yeah, and then once they got through all of that, then they would ask them, and several people turned them down because, one of the things that I talk about in this book, it's hard. It is actually really hard to be a plaintiff, to be a regular person, and then one day, basically, you're the face, of this litigation, and you're the one that has to step out in front of TV cameras when you've never talked to a reporter before, and you're the one that has to wade into a crowd on the first day of the trial. And there's protesters everywhere, and you're worried about your kids, and it's not easy. And I really try to detail what it's like in this book, so they were really running out of time, and they finally found these two couples, Jeff and Paul, who are from Burbank, and Chris and Sandy, who live in Berkeley, and.
Nice
Chris was
geographic spacing.
Chris was somebody that Chad knew.
Chad
right?
knew, yeah, and they didn't realize that her marriage had been one of the ones that was annulled. They thought they were married, so.
And so you have the plaintiffs, you have the legal team, and you have sort of the PR aspect of it with Chad Griffin. But let's talk a little bit about the legal aspects of this case, because the case is filed. It goes to a San Francisco district court judge, federal district court judge. Ted Olson wanted it fast-tracked to the U.S. Supreme Court. He wanted it in front of the Supreme Court as fast as possible. Not everybody really agreed with that, so he asked for a preliminary injunction and ended up not getting it. The Judge Walker, said, no, we're going to have a trial.
Yeah, Judge Walker, Judge Walker's decision to do that was the best thing that happened to this case. But I think undeniably, because everything went on trial. When I talk about this in the book. You talk about this, evidence on the science of sexuality, evidence on what makes a good parent. All of these issues. What is the role of religion in the public square? Religion played a role in the passage of Proposition 8. And so all of that went on trial, and I think, I think really de-risked, if that's even a word, the case. I mean, this was a risky case. I mean, and by doing this, I think Judge Walker really made it a lot less risky, because one by one, as the evidence was presented, and all of these reasons that had been offered for why the state was right to say that certain kinds of couples should marry but others shouldn't, because the state has to have a reason when it discriminates. Each of those reasons were subjected to the crucible of cross-examination. And so I think that was a huge decision.
Well, let me just add, I think it was de-risked as of the end of the trial, but I think going into the trial, even if you had asked David, he would have said that a trial poses high risk because you have witnesses, and much as you prepare a little bit for, ahead of time for what they're going to talk about, you don't want to rehearse it to death and have it be really canned, and you don't know exactly how it's going to play out, and then you don't know how they're going to fare under cross-examination. So a lot of the planning, I mean, the one of the other thing, I think Judge Walker's decision to have a trial was huge, and it made a huge difference. And I think I always wanted a trial in the state case, and part of it was because you don't get to yes with people who don't understand until you present them with the facts and the debate and the discussion in an open way, and that's what the trial sort of allowed to happen. But
this is the first time that sort of being gay is kind of put on trial.
From every single angle.
Right. Can you change your sexuality? What's been the history of discrimination? Which was...
Davis, there's a chapter about this history, and for people, that don't know, I mean, in fact, some younger people, who are gay don't maybe even understand this history. It was, going all the way back to, even before Stonewall, and some of the ways that, the gay people were hunted down in bars by plainclothes officers. I mean, Terry did that witness, and it was, the court was riveted.
People, even gay people,
Talk about that witness, Terry, for just a second. Who
His name is George Chauncey, and we had worked with him and put a declaration in from him in the California cases, and he was really the first professor to study and make a sort of a subject and almost department out of gay history. The only thing is I wish he would study lesbian history a little more, but he talked about the government's role. There was a huge sort of anti-gay effort by the U.S. government, by the medical establishment, and the effect on gay people was to be in the closet, which meant you couldn't really politically organize because you can't politically organize from inside your closet. It doesn't work very well. So he laid out a lot of facts about the things that gay people were called by the U.S. government and by state governments, that they were drummed out of their jobs.
Couldn't serve in the federal government.
That they were entrapped into being prosecuted for solicitation, gay men especially, that women, if they looked too mannish in a bar, they would be, or a restaurant would be kicked out.
This is all going into the court record as
right.
part of this trial.
Right, and he tells it in a really compelling way, and he also talked about the early ballot measure that Anita Bryant waged in Florida, and when you listen to him talk about that testimony, it described a ballot measure that, while a little, as he put it, less polite and more sort of nasty in the way it called gays perverts and things like that than the Prop 8 campaign, there were many, many parallels. And he kind of laid it up to talk about some of the messaging in the Prop 8 campaign that wasn't on the surface, as it didn't appear insidious until you started really peeling back the layers and thinking about it.
Save Our Children, Anita Bryant, 1977.
Exactly. And Prop 8, Protect Our Children, was a big theme.
Joe, and you take us inside this testimony. It's fascinating.
Well, the one of the stories that I found really interesting was the testimony about stigma, and essentially this is it was important. They were trying to almost. In the Brown v. Board of Ed cases, just to kind of back up to the previous entry, there was this great, amazing doll study, and what it showed was that, when you are discriminated against, you start to think of yourself almost as bad. So this was children that went to segregated schools were asked to pick which doll they liked better, the white doll or the black doll, and they would pick the white doll. And so there was a lot of testimony about stigma. And one of the things that I try to do in the book is sort of, I want people to understand the testimony because the evidence is important. And it's being, by the way, this trial record has been cited in every single federal decision since the Supreme Court rule. So you've had a number of federal courts strike down bans in other states, and this record has been cited in each of those cases. But what I try to do is sort of always try to come back to how the people were feeling. And so one of the witnesses afterwards, everybody kind of went to have a drink, and the lawyers who had prepped him, several of whom were gay, they started talking about it. And the testimony that day had been about sort of, about little things, about how you feel like when you go to your doctor's office and it says, married or married or single or divorced, and there's like no box for you. And anyhow, some of the gay lawyers were talking about this, and they said, it's almost like being on a couch. Like in the court, you're in, your lawyer mode. But afterwards, one of the young women on the team, Sarah Pipemeyer, said, was talking about how it took her for the longest time to call her wife, who she married during the window when it was legal in California before Prop 8 passed, that her wife, to introduce her that way.
As my wife. Yeah.
As my wife, because she said, it felt like a word that was reserved for other people, And then the witness was saying, yeah, that was the same thing with my husband. And so, it was interesting to me because, these lawyers, another example is, Terry and another of the young lawyers having to go through all of this evidence of animus. And then going home at the end of the day, it's a little bit different.
Animus towards gays and lesbians.
Animus towards gays and lesbians. So it's, searching for, kind of speech that shows that, people were really prejudiced and so on. And would go home in this horrible mood because it's not the same as researching, something for a patent dispute. It's, this is literature that you're going through, and it's great. I found a great one because this is perfect for the trial, but it makes you feel something when you read because it's about you.
There were a lot of really interesting witnesses at this trial that in some ways was almost as important as the Supreme Court ruling itself, which in the end really just said that the people who were defending Prop 8 didn't have standing in the case. So it was a very limited ruling, as most folks probably understand. So this trial was almost equally important to the ruling itself.
More important.
More important. I mean, it was a truth commission. It was the first time, I think, that I know of, that a movement, a community, has been on trial from every aspect, every facet of their lives. I happen to be the place where Lee Badgett, who's an economist, who was one of the witnesses, she stays with me when she comes to town, and so I remember sending her off to San Francisco, and she was wondering what she should wear, and it's incredible to hear a psychologist, a historian, Mayor Jerry Sanders, the young fellow who was the Denver police person who had
Well, you mentioned
suffered.
Mayor Sanders, the San Diego mayor,
Right.
who initially opposed gay marriage and came around, and you called as a witness. Did you call as a witness? Or?
We called him, our office did, and Ted and David understandably were actually kind of reticent because he posed a little bit of risk. But the same risk was also the reward that you would get from Sanders. And Sanders we had come across when we were doing the California marriage cases, and we went down to San Diego to try to get them to do an amicus brief, to join an amicus brief. And the council was there, but the mayor was going to veto that because he had taken a position that civil unions were good enough. And he was about to veto it, and his daughter, who was a lesbian, basically said, yeah, go ahead and veto it, because otherwise you won't get reelected. And so he thought the gay community would understand. He hadn't ever been really hateful toward the gay community, but he got together with some neighbors and friends who were gay to sort of tell them and ahead of time so that they wouldn't, so they would understand. And as he started to talk to them, they started to talk to him, and they said, Jerry, we walk by here with our daughter every day, and you see her in her stroller, and you say hello to us. What, you think we're not a family like you? And one by one, they had story after story, and he realized in that moment, oh my God, I have been harboring this prejudice, and I didn't even see it that way, and I could have made this horrible mistake. And so he went out the next day and did this press conference and said, I'm not going to veto the resolution. And he barely could stop. He didn't stop crying. He kept crying.
And
he
even
said,
in the courtroom that day, he was crying.
He was crying. And he said, I came so close. I can't bear to tell a whole group of people that their lives are less meaningful than my life.
So Joe, let's talk about a couple of things they were trying to do in this trial. They were trying to establish being gay and lesbian as not a choice, and talk a bit about that. I mean, this is all toward an end, this testimony.
Yeah, I mean, even Jerry Sanders' testimony was about, showing, and this is important because the argument on the other side was, look, all these millions of Californians that went to the polls and voted for Proposition 8, they couldn't all have been motivated by prejudice. That was the argument. Well, Jerry Sanders, Terry understood was an important witness to put on, because he showed that by acknowledging his own unthinking prejudice, that prejudice doesn't have to be, sort of out and out bigotry. It can be unthinking, which is, kind of legally important. But all of these things, like the testimony about sexuality not being a choice. There's a kind of a funny moment because the witness on the guy who cross-examined him, it had a very dry and plodding manner, and at one point, David...
interviewing the professor of, what was he? He was an academic on human sexuality or something.
Yeah.
Oh.
And
For days, it felt like. It was
did feel
hours
like
and
days.
hours.
But he, at one point, David Boyd said, you got to hand it to the guy's name was Howard Nielsen. You got to hand it to Nielsen. He's making sex boring. There's this moment in the book. But yeah, no, it was really important because, they wanted, if it's not a choice, then the court, potentially could apply a higher bar. In other words, this, as I said earlier, you have to have a reason when you discriminate. And the bar gets a lot higher under certain circumstances. So,
well, for certain classes of folks, like
exactly.
African Americans.
Yeah, like gender
women,
is not changeable, and race is not changeable. And so those laws that discriminate on those bases get subject to kind of more scrutiny by the court.
What's known as heightened scrutiny, and so it's defining a group of people as a suspect class.
Right.
I just want to educate folks here, because this actually applies to a lot of cases that we hear about all the time. Is it a suspect class? Will a court apply heightened scrutiny? So maybe one of you could sort of describe what
Sure,
that means when you apply heightened scrutiny.
There are
Scrutiny.
really pretty much only two groups, maybe three, depending on how you look at it, that the court has historically said heightened scrutiny or strict scrutiny applies. Based on race or national origin is one. I kind of lump those together. But gender gets heightened scrutiny, and religious affiliation does, but partly for other reasons, because the First Amendment protects that right. But to evaluate that, the courts look at whether there's been a history of discrimination, whether the difference of the group that's targeted for unequal treatment is one that prevents them from being able to perform equally in society in general, and whether the characteristic that makes them different is something they can change, or is immutable. Let's see, there's a fourth factor. Political power, whether they have the ability to protect themselves in the political process. So those four issues were areas of testimony at trial. A lot of the other testimony went to the other side of the coin, so we didn't know if the court was going to apply a heightened level of scrutiny, in which case our burden would be a lot lower, because the court would say, well, if you have to overcome strict scrutiny, you have to show a really compelling reason to treat people differently. Yeah. But if it doesn't apply a heightened level of scrutiny, then it's what they call the rational basis test, which means basically any old reason will do.
Normally.
And so we were trying to prove that there wasn't even any old reason. There wasn't any rational reason, and that the reasons that were being advanced really, if you unpacked them, amounted to prejudice, and not always the bigoted kind of hateful prejudice, although that was there, but a lot of unconscious beliefs that people were different, which really weren't supported by any evidence.
So this is why this trial is so important, and I want to get back to you, Tori, on some of the politics of this, but one more question for you, Joe, and that is, you talk about one witness who is described as the naughty boy.
Yes.
So, and this gets into a little bit of the politics behind Prop 8 and the passage of Prop 8. So who was the naughty boy and why was he naughty?
His name was William Tam, and William Tam was one of the official proponents who put Prop 8 on the ballot. And he was called, there was a joke going around, and I talk about this in the book, Tam's on the lam. They couldn't find him. They wanted to get him. They wanted to put him on the stand because some of what he had written was really quite, even by, one of the things I talk about, we can get to a little bit, is, that when the lawyer defending Prop 8 found out some of what Tam had written, he didn't know, but it came out in discovery, he was like, ugh. Oh no,
Well, give us an example.
Oh, I mean,
we're not broadcasting, so you can say anything you want to say.
He said that gays are more likely to molest children,
Yeah.
that
12 times
they're
more likely, right.
diseased, that it just went all the old tropes that have been. But just this, that it would lead to bestiality and to polygamy and.
So
the joke, in the little war rooms where everybody was plotting the strategy and I was wandering in and out of it, was that when David Boyce sort of takes off his glasses, it's time to watch out. So David Boyce gets this guy, William Tam, we finally gets him to court, gets him on the stand, and afterwards, Olson said, I write about this, like, it would have been possible to feel sorry for him, but for, the kind of these views that he was expressing. But at one point, he begged the judge to take a break just to get away from David. and David saw him out in the hall, and he was talking to his lawyer, and he was, comparing, and normally, like, attorneys don't ask questions that they don't know the answer to. But as I write in the book, not all attorneys are David Boyce, so he kind of had a hunch, and so he asked him what he'd been talking about, and he said, that David was making him feel like a naughty boy.
Well, and he was taking him down these series of questions that would lead Tam to kind of agree, well, yeah, that was a stupid thing that I said or that I wrote or that
Only
it didn't
he wouldn't agree that it was stupid.
Although it was sort of obvious, but yeah.
He would say, well, I believe in it. And then David would say, well, what do you base that on? Well, I read it on the internet.
Yeah.
Well, what did you read it on the internet? But my favorite moment there was he said something like, one of the things that David cross-examined him on was a statement that he made that San Francisco is ruled by homosexuals. And he's like, well, you said that. Why did you say that? And I'm thinking, we'll stipulate to that. But I didn't.
And we're going to get to Judge Walker here in just a second. So this is happening inside this district courthouse in San Francisco. And one of the reasons I think you focus on Chad Griffin in this book is because he's a PR guy. He's a political guy. He knows that these legal arguments are really important, that establishing the legal record's really important if the case is going to go up to the Supreme Court. But he also knows that, what's being said in the media at the daily news conferences outside is really important. That this is a political game, that this is...
Yeah, Ted, it was interesting about the first days that I was there, and I was there well before the trial started, so as everybody's prepping, Chad is introducing kind of the goals, right, to the team of political operatives that he assembled. And on this whiteboard, there was two things. There was a number, 50%, meaning by the time the Supreme Court, this case was to get to the Supreme Court, the goal was to have over 50%, or at least 50% of America supporting same-sex marriage. It seemed crazy, honestly, and an audacious goal at the time. And the other was an audience of 9, meaning that, yes, we are talking to the American public. We have to move this needle so that the court doesn't feel like it's getting too far out ahead of public opinion if it were to rule in our favor. But what he was saying to the team was, but we're ultimately talking to 9 people. And those are the 9 justices of the Supreme Court. So there was this kind of parallel thing going on throughout. And
Olson would argue you're talking to one justice, Justice Kennedy.
Sure.
That he was actually tailoring some of his arguments.
Yes, they pulled out of Justice Kennedy's 2 landmark opinions, not surprisingly for the legal case. They pulled all of these lines that he had and repeated them over and over again, but also in every press statement. That was, to me, what was interesting, that they used words like, human dignity, which is a hugely important concept to Justice Kennedy, that he's almost, elevated to constitutional principle. So they were always talking at the same time to these two people. And I, look, this litigation was used, and the kind of marquee value of the Boyce-Olson, the kind of media that could attract, they knew that they wanted to leverage that. They ran a public education campaign simultaneously. And one of the things that was funny was when there was all these boxes cluttered all around this conference room, and I said, what's in the boxes? It was 2,000 American flags. And they were to be handed out on the first day of trial, and by the way, many thousands more were ordered over the course of 4.5 years, because they wanted the visuals to be something that was evoked American values, not necessarily gay rights, because they wanted this to be talked about in terms of American values, American civil rights.
This wasn't about winning the right to file joint tax returns or hospital visits. It was couched more in equality terms.
Well, and actually throughout the state cases, and I really pushed Ted on this, we didn't ever call it same-sex marriage because it made it sound like some different species or different right. And what we were seeking was marriage.
And nobody gets same-sex married.
Right, exactly. And so I think the goal was, as Joe said, that to make it, to make people realize that all gay people wanted was what everybody else in American society wants. And for many people, not all, marriage is among those things.
So I'm curious, Tori, this trial is going on in San Francisco. You're here in Los Angeles. You're witnessing it from Los Angeles. What is the talk among gay rights activists, in Los Angeles? Obviously, there's a ton of attention to the case, and there is some initial trepidation, we know that, about taking this to the federal courts.
I think there were a lot of people inside the kind of established gay rights infrastructure who were very hesitant, not just the legal folks, but if you remember HRC and NGLTF all signed up, every gay organization signed on protesting Chad et al. Moving forward with this case. So there was but remember, you had 1 million people in the streets, you had a constituency that said, we want to move faster. We don't trust these guys anymore. They brought us a lousy campaign that lost our rights, and so we're willing to try something new. And it was as if the movement, and not just LGBT, but allies, that was being organized through all of these organizations that I mentioned earlier. This kind of, there was a fresh start to the movement. There was a regenerated grassroots
so
that was out there going door to door.
The streets were more supportive of this than the traditional.
I don't think there was anybody. I mean, I was working on Camp Courage. We did, trained 1,700 people in kind of storytelling, movement, going door to door, building coalitions, multiracial, post-Prop 8, as part of this kind of upsurge of organizing and wanting to change the conversation and change how the movement was organized, and frankly, throw down that a new generation was coming into leadership and was not going to wait for a 25-year, 25-state strategy. So in a sense, what all that organizing was to create a grassroots audience and a grassroots constituency that was following this trial and taking the messages of the trial to home around the dining room tables, to mom and dad, and it was a really interesting interplay, and that's exactly what Chad knew, which is what I meant, that the movement moment kind of created the possibility that this wasn't just one impact litigation in one courtroom there in San Francisco, but in fact it was a brilliantly orchestrated, not just PR, it was a political campaign that had a grassroots base that took it home to Iowa and Arkansas, and so the conversation around our circles, I mean, everybody, I think, in Los Angeles of the activists, the new generation of the activists was loving it, we couldn't watch it on TV, of course, as you know, but there was lots of drawings, and there was the YouTube, and then there was 8, and then there was the news coverage of it, 8 meaning the play, the reenactment, And it was, so I think it changed the conversation, and there was a willing audience for it that became the door knockers
and participants. I mean,
Right.
one of the things, this is this great moment. So the Supreme Court, there was a Judge Walker wanted to televise this broadcast, this trial. And there was all this back and forth. The other side did not want these stories to be seen. They did not want, this, and went all the way to the Supreme Court. But
The pro-Prop 8, the anti-gay marriage side did not want it televised.
correct. And so at one point, there's this moment where Judge Walker says, I don't think I need to seek public input as a matter of law in order to televise this or broadcast this trial, but I'm going to do it anyway. So Chad calls Rick Jacobs at the Courage Campaign and says, dude, you got to get on this. and I described this,
Overnight,
what happens
40,000.
in 40,000 letters, more. It was a little bit more, I think.
45,000.
Yeah. Were delivered in boxes to Judge Walker's chambers. I mean, just all paper. I mean, not even emails these days. That's not an easy thing to do. And they got it. They got it done. And I think the other side. I mean, it was hardly any. And it ended up memorialized that effort. Nobody knew how this actually happened, and that's one of the things that I report in the book. But it was memorialized in the dissent. The justices ended up stopping it, but in dissent, it was Breyer wrote, how much more input do you want? There was 40,000. So it's actually in a Supreme Court opinion, although not with. The Jacob, so.
Let's talk about Judge Walker for just a second. He's a Reagan appointee, this U.S. District Judge in San Francisco who heard the trial, heard the case. He's sort of quietly gay. He's not in the closet. You got to interview him, which never happens. We journalists love interviewing judges when we can, but they never talk.
Yeah, I mean, that was, for me, one of the highlights because, of course, I sat in the courtroom every day and, like everybody else, thought, what is Judge Walker thinking about this and so? And about, shortly after he was named, the plaintiff's team understood, that he was gay.
They did a little research, found out he was gay.
Yeah, I mean, and it turns out that the other side did too. But they
didn't ask for a new judge. The anti-gay marriage folks.
Not at that point.
Yeah.
So at and why there's no legal reason to. I mean, women hear judges hear sex discrimination case. African American judges hear race cases all the time. So I talked to him a little bit, and he said, when he first when this case first landed. On his desk, he was sort of like, "Who, Schwarzenegger? What is this? Who's suing the governor?"
Right.
And he kind of starts to page through it. He quickly understands the significance, and he says some version of "Oh shoot," and I thought, because he thought he was worried that maybe that his own sexuality would become an issue. No, it was because he actually wanted to retire, and he knew that he thought he would have to hold a trial, and this would put that off. But he said, like, for most of the trial, he was in his judge mode. Judges often have personal experiences that they bring to the table, and I'm not on trial, so he's just listening to the evidence. But one witness was very different for him, and this was a guy named Ryan Kendall. And Terry, actually, she was the one that really insisted that they put on Ryan Kendall because she wanted to show the harm that is caused by treating sexual orientation like a choice. And Ryan Kendall had grown up in Colorado, and his family was evangelical Christians, and they had forced him to attend conversion therapy, which is now widely repudiated and illegal in California. But he talked about this experience of being, sort of, suicidal as they are trying to force him to be straight. And Judge Walker in this moment told me, it was one of the most moving things. He said he was just transported back in time because when he was in his 30s, he too had attended a form of conversion therapy. He had gone to a psychiatrist. He said and he was describing it to me. He goes, because I wanted to, address and he sort of paused, and he's like, affliction. Affliction. I mean, that back when he was growing up and when he was a young man, this was a mental illness, treated as a mental illness. And he went to this therapy, and he talked about how around the same time, because he thought his whole life he couldn't live the life that he wanted. He couldn't attain the kind of goals that he wanted and be gay. Sort of like, Chad Griffin feeling like he could never run for governor. Again, this diminished sense of possibility when you're discriminated against. And so he had done this, and around the same time he had talked to his parents, and he was passing through Chicago, and they met him, and he said that the conversation took a kind of surprising turn, and they started talking about their sex life, and they acknowledged that yes, they had had difficulties in this area, but that would have been the time for him to say, me too, and it's because I'm gay. And he said, but he didn't want to say that because he didn't want to admit that he was one of those, quote, deviants, and that's how people. That is how people were treated. And so he said, in the end, that to him, the most touching testimony of all was that given by Ryan Kendall.
Yeah, and this is Judge Walker, who has since retired.
Yes, who has since retired. My other favorite Judge Walker story is he runs in. So he issues his decision. It's quite sweeping. That's then appealed to the Ninth Circuit. There's a panel that reviews it. They uphold his decision, but on far narrower grounds. And he goes to the Ninth Circuit Judicial Conference in Hawaii, and this is in the book among the many little stories, but he sees Judge Reinhardt, who is the author of the narrower opinion and considered the liberal lion, of the Ninth Circuit, but he's written this quite, restrained opinion. And Judge Walker says to him, I wish you would have decided this case on broader and, frankly, in his view, more defensible grounds. And Judge Reinhardt, referring to the Supreme Court, says, you have more faith in those people than I do. So again, that kind of strain all along the way of people who were worried about what the Supreme Court would do.
I want to take a couple of questions. We have 15, 20 minutes left here, so maybe raise your hand if you have a question. I want to ask, while we find that person.
Can we ask where the title came from?
Forcing
yeah,
the Spring.
sure.
Yes, it's a great story.
So Forcing the Spring, I was searching for a title, and I read, the title has a bit of irony because it comes from Bill Clinton's first inaugural speech. And in that speech, he talks about how this ceremony takes place in the depth of winter, but by our words, by our deeds, we force the spring. And he went on to say how America changes not for change's sake, but to preserve our fundamental values of liberty and equality. And he then says, each generation of Americans defines what it means to be an American. And of course, the irony is Bill Clinton's generation did not define being American as embracing marriage equality. He signed DOMA,
Right.
the law that defined marriage.
Don't ask, don't tell, and DOMA.
And exactly. But this generation, the millennials, this is a touchstone issue for them. So Forcing the Spring evokes to me, and that look, change was coming. There's just no question, with or without all of the people that I've written about, change eventually was coming because young people, they don't get it. They just don't understand why we're even debating this. The question was, how fast? How fast was change going to come? That was the question, that divided the community. And so I just thought it was a apt title because I thought it sort of took note of the fact that it was coming.
I remember when Lambda Legal, Paula Edelbrick and Tom Stoddard, who are both gone now, may they rest in peace, traveled the country with a road show, and this would have been in the late 80s, early 90s, in which they debated marriage to gay audiences. Hundreds of people would show up, and it was actually so Paula took the anti-gay marriage, the anti-marriage equality, from a kind of a feminist perspective, that this was oppressive to women. It was a history of sort of a failed institution with 50% divorce rate. Why would we want to emulate it? The kind of radical perspective, and Tom Stoddard was sticking up for marriage equality. It was a kind of a gendered thing. You would have 500 people in an audience and lots of argument, and so it's just interesting. that
you know,
this issue became the issue in a conservative time, and then this lawsuit and this case, which I think really had more to do with the fact that once you had 18,000 people married, and then you had a campaign that didn't allow them to be the center of the campaign, and then have them take their rights away right as you elect a president and move the country forward and then backward at the same time. It was a cataclysmic.
You know, that came up at the trial, actually. The other side, the defenders of Proposition 8, used this notion that, like, well, this hasn't always been a goal of the movement.
Right.
And in fact, some people in the movement
It's true.
didn't want it. And I write about that. And, you know, one day after court, one of the main characters of this book is Cleve Jones, of course, your friend and creator of the AIDS quilt and, you know, a longtime activist. And, you know, he wanted to take me after court one day and show me where Harvey Milk was shot. And, you know, Harvey Milk was talking about taking this cause federal before he died. And we walked up the stairs at San Francisco City Hall, and there's a large bust of Harvey sitting at the top of these stairs. And one of the moments I'm most fond of, the testimony that day had been about this, that the gay community had not always made this a priority. And Cleve, as we're walking over, says, yeah, that's kind of a bit like saying, you know, that because slaves never demanded to run for governor, you know, I mean, it's like, you know, in the early days, there were so many other battles, just basic things. But he said, you know, he walked to the top of the stairs and he patted Harvey's head, and he said, Harvey, you can't believe what's going on down the street, meaning the trial. So.
Let's take a few questions. I have a few of my own, but let's take some from the audience. Just say your name and maybe what community you're from.
My name is Todd Kerner. I'm from Hermosa Beach. And this is probably more towards Terry and Tori, but I'm curious what lessons you can draw from Proposition 8 and the whole battle with regards to the influence of money in initiatives and the role that initiatives should play in changing our Constitution.
You want that one, Tori?
Why don't you start?
Touchy subject.
I can say we know that
especially
with,
the legal part.
with initiatives, you know, the spending limitations are not as strict as for candidates. So we know there's an enormous amount of money. In fact, you heard in the report, there's more money spent on this battle than on any previous initiative anywhere in the country. So we know there was a lot of money poured into it.
It was 80 million, as I recall, 40 million each side. You know, I think California has one of the easiest constitutions to amend and one of the easiest initiative processes in terms of putting something on the ballot. And there are about 25 states that have the initiative process, but not all of those allow the Constitution to be amended by initiative. And I think having it possible easily and as long as you have money to change the state constitution renders the state constitution a pretty weak document, especially on things that involve rights of a minority or rights of somebody who might be unpopular. You know, I don't think there is a limit on how much you can contribute to an initiative battle. So huge amounts were contributed. They were contributed on both sides, but in the end, you know, it's really a popularity contest as long as you have equal money. And if you don't have equal money, then it's purely a money contest.
Well, and in the book, you know, I described some of the testimony on this, and you know, I didn't know this going in, but, you know, no group in America has been targeted by initiatives more than gays and lesbians. That's astonishing.
Right. It started, as I mentioned earlier, with Anita Bryant. Actually, I think there may have been one before that, but that's the first one that got any
St. Paul.
attention to roll back an anti-discrimination measure. And then they across the country, every place that had those measures, when gays would achieve anything in the political process, then we would be met with this backlash and almost immediate reversal. And then by the time of marriage, Karl Rove had the brilliant idea to get it constitutionalized as a way to bring out the vote for the Republicans. And that made political progress even harder, because to amend the Constitution, you've got to not only raise massive amounts of money, but you've got to win against the other side again. So it's a really thank God we don't have it for the federal Constitution, is all I can say. I wish in California we would revise the initiative process to make it tougher to amend the Constitution, because I don't think it's, it makes the Constitution a lot less of a bulwark against somebody taking away important rights.
One of the interesting things about the Supreme Court ruling is that, of course, it said that the pro-Prop 8 folks did not have standing in this case, and therefore Judge Walker's ruling stood. And so now folks who are bringing initiatives in California are writing into their initiatives that if they pass, that they would be able to defend them. Normally, of course, it'd be the state attorney general or the governor who would defend them. In the case of 8, it would have been Jerry Brown, who was then attorney general, and then Kamala Harris. Neither chose to defend Prop 8. So it's created sort of a very interesting dynamic in
Although
that regard.
I don't know if it's going to carry the day with the Supreme Court, because part of what the Supreme Court was saying is, we can't let people just create standing,
Right, yeah, right.
by popular vote, and that if you're unelected and you're not really the normal person to determine how to carry out the legal
Right.
interests of the state,
They're going to try, though.
they absolutely are going to try.
So we would be remiss if we didn't address some of the controversy out there around this book. And there are a couple other questions, but I want to get to this one too, and maybe one or two from the audience. But folks like Andrew Sullivan and a couple of others have pretty strongly criticized your book. I think one called it a distortion of history. My sense is their main concern is that you describe this as, sort of the beginning of the marriage equality revolution. Their argument is that, of course, it started much earlier than this, and that there's almost too much credit given to Chad Griffin and Ted Olson and David Boies.
Yeah, I mean, I think that if I had set out to write the history of the movement or even the history of the marriage equality movement, their criticism would be completely fair. I didn't do that. I really just wanted to write about a case, and a Supreme Court case. And there's been, Supreme Court cases they have this great arc. A lot of people have written about them in the civil rights. There's been books written about some of the great civil rights cases of the previous century, as well as separate books that are written about certain leaders within the community, like Taylor Branch's amazing "Parting the Waters." I think that there is, room for many, many books. Mm-hmm. This movement has had so many heroes all throughout, and I think that I think that what happened though in what I try to describe what this story is about. This story was about a group of people that decided to do something pretty radical, pretty revolutionary, which is buck the entire establishment and take this cause to the Supreme Court. They didn't end up getting exactly what they wanted, but they did get, I was in San Francisco on the day that marriages resumed, and people were coming down and pressing flowers into Chris and Sandy's hands and crying and thanking them as they themselves lined up to get married. So it's not what they wanted or set out for, but 1/5 of the country now had marriage equality. That was a pretty big thing, but again, there's so many people that should be celebrated. I know that there are more books about to be written on different aspects of this, and no one book could cover all of the people who have contributed.
Well, and
to
it would
this
be hard to say that it's not significant that Californian gays and lesbians can marry now. At the same time, it was the narrowest ruling. The smallest victory that could have been won, obviously.
Sure, especially when you set up against the expectations, like.
And I think
the other scenario would have been that they ruled the other way, that they said that Prop 8 could have stood.
But of course, they didn't know what the results were going to be.
Well,
I think
let me ask
important.
you this, because I think you followed this a lot. Is the other case, and part of the criticism of your book, and again, I think people need to accept that this is about the Prop 8 battle, and this is a behind-the-scenes, granular look with these amazing characters. But I think part of the discussion is the other DOMA case, the Windsor case.
We want to see the lesbians in just as granular, just as big a book.
Well, actually, let me just jump in
That's not
here.
the point. What I wanted to get at was.
Well, wait a minute.
But
I
let me
wanna go to
ask
that
you.
point.
Well, let me ask you this. I mean, some would argue, and maybe Joe, you would argue this too. I don't know, that in some ways the Prop 8 battle and case was more of a political and social victory.
Yes.
And that the DOMA case, which partly overturned the Defense of Marriage Act, the Windsor case as it's called, was more important legally. So maybe, Terry, you could start out.
It's even hard to say that. I mean, I think it is true that the social kind of political, storytelling and messaging behind this whole effort, which was broader than even just the legal case, but it was the whole
It was the
effort.
Chad Griffin PR machine.
Exactly. And that was hugely important, and that was bigger than the ruling that they got out of the Supreme Court. But I think that the trial itself proved and disproved some things that have been, as I think Joe noted earlier when we were chatting, that a lot of the courts that have now been considering the issue in other jurisdictions have cited. And I think it kind of created a template for, there's been at least one, I think maybe two more trials.
And but they're also citing
right.
the Windsor DOMA case, too.
Yes, but the Windsor case is important. It's not just the Windsor case, by the way. I mean, I always think of it, there were about a half dozen DOMA cases, and the one that really should have gone up was the Glad case, that had about 10 plaintiffs and would have been more of a story. But the Windsor case was the one that Kagan had already gone to the court by the time that case was
And it's
filed.
worth-
And it's a great story.
It is a great
Come on.
story.
I mean, what better heroine than Edie Windsor?
Exactly.
And I
so-
do get to talk, I mean, I was fortunate to talk to Edie and her lawyer, Robbie, and I didn't, have the same kind of I'm wandering in and out of their war rooms, but some of the stories that I do tell about the Windsor case, I love this one moment where Edie has just won her the circuit case, and and she goes home that night and she's rummaging around her drawer, and I was in her apartment. I mean, every single it is what a marriage. I mean, every single tabletop, every wall is covered with pictures of her and Thea, and she's going around and she's kind of rummaging through a drawer, and she pulls out this piece of crumpled up paper, and it's the day that she's won this decision, this important decision on the path to the Supreme Court, and it says, she unfolds it, and she tells me she thinks it was when she quit smoking that her wife sent her this, but it says, "Congratulations, darling, you did it." And it was like Edie called Robbie Kaplan, her lawyer, and Robbie said, I write about this in the book, it's why she believes in God,
Well, Thea had died by that point, in case, for
yeah.
those of you who don't know.
Yeah, but I mean, Edie Windsor is a wonderful one, also an amazing plaintiff, not handpicked. She just she got mad when she got that, that tax
I
bill.
think your coverage, it wasn't the focus, it wasn't where you were embedded, but I think you covered it beautifully, and I think you made it come alive. You made that whole case
So
come
let
alive.
me, my job as a reporter is to ask the uncomfortable questions, right? So let me ask you, Terry and Tori. I mean, this book does start out, "This is how a revolution begins." Is this where the revolution began? Was there sort of maybe a new aspect of the revolution that began? Do you sort of
I think there
agree
was
with
a-
that characterization?
I agree that the revolution was had a resurgence. There was a rebirth.
With the Prop 8 case?
Yes, the Prop 8 was a moment that everybody here in this room, that everybody in California, it affected their life at some point or another, gay or straight, whether they were in the streets or they were just watching those marriages happen from 2004 on and wondering what was going to happen. It became the issue, it became the moral center, not just of the LGBT movement, but of civil rights in general. It was the urgent issue, and that was when the revolution began. I don't think that Chad Griffin can be analogized to Rosa Parks. I think Rosa Parks was a movement person. Chad Griffin was an outsider, and in fact, that's exactly why, because of the widespread movement moment, that he was able to kind of bring in a whole fresh approach and bring in a political approach and do a whole PR thing. I think my one concern about the book, and I want everybody to read it because it's a thrilling ride, is that it kind of sets up this idea that it's single cases that change history. And in fact, there's a much more complex history to a social movement. And it really is, the reason that revolution was important was because of those million people on the streets.
Yeah, okay.
Honestly,
All
the
right.
tens of thousands
So-
of people who became movement organizers for the first time because of that contradiction that night.
Terry, you
And
wanna add to
people
that?
make history.
Well, I think Joe explained what she was thinking by revolution, and I think what Tori described is really it. It's about a point in time where people got frustrated, and some of the things that, we had gained marriage equality in California. It was such an amazing thing, and then it was taken away.
Right.
And people were angry about it. And whether or not you think the
Un-American.
campaign was well run or not, it didn't succeed. And so I think it was a point, and it was a momentous point when this young guy, with the impatience of youth, decided, damn it, I'm going to do something about this. I
it took the
don't read the
movement-
book as saying nothing happened before that. And in fact, there's lots of places where in the book that allude to prior, she mentions Mary and her
Okay.
victory in
All right.
Massachusetts and California. And it's not just me, by the way. Shannon Minter was in that case as well. So I don't come away from it thinking, there was nothing before.
Right, okay. So, Joe, we're talking about your book, and you're just sitting here sort of politely listening. I love it. Do you want to say anything? Because I want to get one more question in.
Sure. No, just to kind of augment that, it's like Rosa Parks and her generation of leaders faced unique and terrible challenges, and nothing can match that bravery. The point that I was making is that at certain moments in history, change happens because people say, I don't want to wait more for justice, and that has happened throughout the gay rights movement. That happened at Stonewall. It happened in the 80s with AIDS activists. It happened
In 1991 here in Los Angeles when Governor Wilson vetoed AB 101, and there were 50,000 people on the
Okay,
streets.
one
And
more
Mary, but-
question, then we got it. We're going to wrap it up. Oh, we got a couple more questions. So we'll get as many questions as we can get in. Sir.
Hi,
say,
my name is...
say your name and where you're from.
Yeah, my name is Ryan Bell. I'm from here in Pasadena. It was widely reported in the campaign for Prop 8 that it was, driven and funded by religious groups, and religion played a large role in the passage of Prop 8. And then in the revamping of the movement that you talk about, the sort of rethinking of the role of religion in the movement. I wonder if, Joe, in your book, how much you talk about religion and its role in all of this, whether it's over-reported that religion drove this, or whether, and what role religion plays in the eventual overturning of Prop 8.
Sure. There's an entire chapter, I think it's called God versus Gays, and there was a real concern that Ted Olson had, and I talk about this. It's not like everybody has their kind of genius moments, and this is not one of Ted's. He was sort of talking about he didn't want to bring religion into this. He kind of was worried about how that would go over with the, all the justices. So how many of the justices are Catholic? 6, I think. He just didn't. He was
Really?
worried. Is it 6? I think that's right. He was worried about it, and he didn't want people to think this was God versus gays, which is where the chapter title comes from. And Terry was really instrumental in saying you cannot talk about this and the prejudice that drove it. Which was important to talk about. The prejudice part of it was important legally. You can't talk about that without bringing religion in, because there was so much going on in terms of organizing. There was and some of the great discovery and these moments that I talk about in this thing is like they got all this great discovery, and they found there was this pastor's rapid response team, and they were really, this was...
Every Catholic parish had to have a yes on 8 inside the church somewhere.
Yeah.
There was a big Sub Rosa campaign that there were sort of 2 campaigns during Prop 8 that the Yes on 8 folks ran. One was the one that people saw on their computer screens or their televisions that were the sort of the ads aimed at the mainstream, not necessarily religious people. And then there was a very strong in the church, particularly evangelical churches, but also on the ground, walking house to house. I mean, it's really quite admirable how successful they were.
They ran a brilliant campaign. It was really a multiracial religious coalition. The right wing ran it brilliantly. They had people walking door to door in every black and brown neighborhood in the state, and they out-organized the No on 8.
But just to go to the question that the gentleman asked, one thing that changed was, I mean, there were religious organizations, churches that were supportive of marriage equality from the get-go for a long time back. And they filed amicus briefs in the earlier cases in California and elsewhere. But the team that worked, Ted and others, on the Perry case as it went to the higher courts, solicited the religious organizations that were in favor of marriage equality to try
as did the Windsor team, yeah.
Right, to try to demonstrate that it's not monolithic, that religion has been on both sides.
And just to speak, one of the measures of change that has occurred just in these last, 5 years is that, I think this issue used to divide Americans largely, along religious and secular lines. And now, I talk a lot about how it actually divides religious Americans. Young evangelical voters are almost at 50% support. I
remember going up to Fuller Seminary sometime in the period after that, and a lot of the young students were fine with it.
Yeah.
We're fine with it.
And the Mormon Church, for instance, is no longer in the business of funding initiatives like Proposition 8. They've changed. They have not gotten involved.
We're going to get another question, and you're pointing at somebody. I can't tell who.
There's a young woman in the back. Oh, it's the woman who holds the microphone. Okay, there we go.
Hi. So I tried to write down this question.
Maybe we sneak two questions in if we keep them
so
really
it'll be
fast.
Concise. So basically, I think it's important to point out that these battles are still Sabrina. That these battles are still happening in other states, and I'm curious to know what combined perspective can the three of you bring together to send a message to adults and youths that are still fighting this battle.
Well, I think if you pay attention to what HRC and a lot of the other now, the groups that weren't so excited about this case have filed suits all over the country. There is not a state that has a marriage ban on the books where there isn't some kind of challenge pending in federal court, and a few have been in state courts. And now we've seen every lower court of the federal courts that has ruled on the issue has held that it's unconstitutional. I think the Supreme Court, which would probably the liberals and Kennedy would like to put this off, and it really felt like they didn't want the case in front of them when it came.
Yeah, I mean, can I just interject there? I mean, I remember right after, and I write about this in the book, I mean, right after the arguments, Terry, had this moment. I mean, she'd kind of, she'd been someone who was cautious all along and didn't really want to get her hopes up. Like, she had real experience. She'd had that victory that she won, snatched away. She had an experience that Ted and David did not have. But she'd kind of like, by the end, by the arguments, like you'd kind of bought into the whole hope and, change thing. And listening to those justices, like, Terry just felt like, she said it was like having a stiff arm, like, get away from us. Like, why are you bringing this case? And it's, I try always, in this thing to talk about what people, not just what's happening in the court, but what those kind of moments. I mean, you were wrecked that day.
I was, and I wanted Ted to be right. But in any event, I think the court will have to take a case sooner than it would probably like, because these cases are now headed up to the intermediate courts, the courts of appeal, and the courts of appeals are going to be ruling on them, and sooner or later, and probably sooner, there's going to be a conflict, and the high court's going to have to take it again. So I think we're going to get there, but I also think the political organizations and all of the efforts and kind of energy that Tori's been talking about, and she can say more about this, means that people are going into other states, Arkansas and Alabama and Florida and Georgia and Oklahoma and Mississippi, and saying, wait a minute, we've got to change minds here too. And gay people are starting to be more out, and you're seeing pictures of them in the New York Times from places.
But the paradigm shift that happened in the wake of Prop 8 was, and the gentleman over there kind of mentioned to it, was to not shy away from doing organizing within communities of faith, to make sure that faith is at the table and engaged in organizing, to tell personal
And
stories
African-Americans
and
and
go
Latinos.
door to door and talk to everybody you know, and not be afraid to tell your story, whether you're gay or a straight ally. There was a paradigm shift in how organizing was approached, and that has spread through the land. Just today in the New York Times and yesterday in the New York Times, it talked about the 5-state strategy in Arkansas and Alabama, I forget, but the Southern State strategy that HRC and other of the institutions. So I think that what you see is the movement rolls on. There's an interplay between these cases and the magnificent work that Terry has been doing, by the way, for years. I mean, really, and the kind of case that this particular book highlights with the organizing that goes on by people.
Telling stories, again, what I wanted to do with the book was bring to life the stories of the 4 plaintiffs, what it was like for them to go through this, what it feels like, as Chris Perry testified, to want something so badly and be told you can't have it. But ultimately, we've talked a lot about different people who played really important roles, but I think ultimately the most important role is telling stories, because what's happening is, and fascinating moment in the book we didn't really get to, but the fact that a young woman told her story in this book has changed fundamentally the way that the lawyer who fought these plaintiffs all the way to the Supreme Court, a lawyer named Chuck Cooper, his daughter learned midway through the case that he learned midway through the case that his stepdaughter Ashley, was a lesbian.
This is Chuck Cooper, the attorney for the anti-gay marriage pro-Prop 8 folks.
And shockingly, the plaintiffs read this book and they were like floored by the fact that it turned out that even before he knew that, he listened to their stories as they testified. They were just frightened to death that he was going to cross-examine them. Meanwhile, he's sitting in this chair thinking this is why. Legally, he still thinks that he was right. But politically, he said, listening to those plaintiffs testify reminded him that this was an excruciatingly difficult for him political issue. And he said, and it turns out that listening to this trial and going through this trial made him a better father when his daughter did come out to him. So I think, fundamentally, why are we here in America where we are? We can name different people and different leaders, but it's each and every person that goes out and tells their story.
Well, good Lord, there are gays and lesbians everywhere. There's a gay judge in the case, the daughter of the anti-gay marriage lawyer, and maybe even the moderator of this forum. We have another question.
I'm Jason Tafide. I live in La Puente. It seems like this was fought on 2 fronts, a political front to change public opinion and also the legal battle in the Supreme Court. I'm wondering how important the political fight was to the case in the Supreme Court. How important is politics to the High Court? And what do you think about that as an attorney, that if it does play a big role? Could this fight have been won strictly on legal grounds?
Well, that's a great question. I think that earlier I was saying that when the Supreme Court considers an issue, especially an equal protection issue, but even on due process or some of the other clauses where Eighth Amendment for that matter, where a majority of the states or even a supermajority of the states haven't gotten to the place where the court feels the Constitution compels them to go, the court doesn't want to weigh in at that point. So the political battle was hugely important because it moved more states over. And one of the things I was unaware of as we were working on the case was the degree to which Chad and people he gathered, like Melman, this very conservative political guy.
He's the architect.
Well, Ken, don't pass over that. Ken Melman, who was he chairman of the National Republican Party or the chief chairman of the National? Well, there's another gay who's chairman of the National Republican Party.
But he got involved in the New York marriage equality battle.
Chad reached out to him.
As this case is moving along, those of us who are like, oh my God, what are they going to do? There's only a few states, and now the number of states continued to grow as the case went up.
But interestingly, the other side saw that it was a double-edged sword,
Right.
because legally, you know, the idea was, well, on the one hand, the more states, the more comfortable the justices are going to feel. But both lawyers who defended the Prop 8 case and defended the Prop 8 and defended DOMA, they saw it totally different. They thought the more progress that was being made, in a way, the better for them, because they used it to argue, look, you don't need the justices to step in. This is all working itself out.
But, you know, by and large, if you look at, I think by the time the court overruled Bowers and Lawrence, there were something like, I want to say 16 states only that had anti-sodomy laws on the books. By the time the interracial marriage was decided in Loving in 1967, I think there were 11 states. I may have flipped those. I'm always forgetting the numbers. But it's not that it never happens. And the one area that made me think twice was I was looking at this and thinking, well, is there something where they've overruled a majority of the states? And Kennedy did it in an Eighth Amendment case, and maybe more than one, where it involved juveniles being executed or things like that. And he came up with some elaborate explanation of why everybody was really there, even though the laws didn't seem to reflect it in the states. But I think by and large, it's very hard ask for the court to overrule, you know, to overturn laws in effect of a huge majority of states. So I think it does make a difference, but and I think it weighs more in our favor, even though technically the argument about political power, it's funny about the case, everything bad was good and everything good was bad. And
it's true.
The lawyer, like any good developments we would see politically as the case was going along, it would be kind of like, oh no, what does that mean for the case? You know, it'll sound like we have political power, or and everything that happened that was bad was like, oh good, we'll get this in front of the judge. This will, you know. So it's kind of this weird place.
Even the bad, like, you know, it was really devastating to the team that brought the case, that when they said that they couldn't televise the trial. That ended up provoking, you know, we haven't really talked a lot about all the Hollywood people that were involved, but Dustin Lance Black, who was Academy Award-winning screenwriter of Milk, you know, then said, okay, well, if they won't let the American public see these plaintiffs' stories by broadcasting, and I'm going to write a play right out of the transcripts. And so you had a cast of, I mean, you couldn't get this for a blockbuster action film. It was
I was
you know,
there.
yeah. I mean, it was George Clooney and Brad Pitt, and I could go on and on.
Well, not just that though, but like the people were in the courtroom twittering and and tweeting and blogging and all that stuff.
But Walker actually said out of bad came good, because he wanted to broadcast the trial, right? He said, you know, the truth is, if we put this up on C-SPAN or something like that, nobody would have sat through
And a million
all
people
these
saw it on
hours of
YouTube.
testimony. But
Tell them they can't?
1.5 million people
Saw the
watched it on
YouTube.
YouTube because it was George Clooney and Brad Pitt. Brad Pitt playing the judge, by the way.
Well, and I think that's, you know, that's what makes this book so interesting. There are many important legal cases, but certainly this is one of those important legal cases. But you had, in addition to the legal case, Hollywood surrounding it, Chad Griffin, this PR guy, these high-profile lawyers, and of course, a Pulitzer Prize-winning New York Times investigative journalist
What's
telling
your
the story.
next book?
So this is also going to be coming out
Wants a nap.
You tell me afterwards.
In another, sort of completing the masterful PR machine around this case and this story. There'll be a documentary coming out because Chad was smart enough to allow
the
lots
case
of folks.
against 8. Although, you know, it's funny. I was saying this to somebody earlier. You know, it could have. I mean, you say Chad was smart enough, right? He could have turned out to be a total goat, right? A guy who set the movement back decades. If this case had come out another way. So,
Well,
and he would have been dumb enough or smart enough to invite an investigative
and the
reporter
legal-
and a
right.
documentary crew to show just how he screwed it all up.
And in the end, the ruling was
Well, the ruling was
narrow,
narrow.
but by the hair of his chinny chin chin and their chinny chin chin. So the book is available outside. I think you're going to sign copies. Joe Becker, Terry Stewart, Tori Osborne. Thank you guys so much for showing up. You guys are great.
Thank you. Thank you.